Ms. Manica?
Okay, so would you like me in the first instance to answer that last question?
Yes, please.
Okay, so, well, the answer is yes.
Okay, yes.
I think
good. That's always a good answer.
all right. I think you look surprised. Maybe I misunderstood the question, but yes, that by the end of the hearing, in our view, all of those criticisms had essentially been addressed or fallen away. And there were, you heard or you saw yesterday, and I'll turn it over to Mr. Palachik for any detail, but with respect to the one particular adjustment on inflation and elasticity of demand, they washed out, and both experts in conferencing said as much. There was an exchange with respect to the cash flows to equity as opposed to the cash flows to the firm, where the arbitrators were questioning Dr. Abdallah and saying, isn't it the case that it would only be cash flows to the shareholder if there were a number of different sales and you were using the weighted average cost of capital, the WACC of the shareholder, rather than the company, which is not what happened here. And Dr. Abdallah agreed that that was not how the transaction was structured, that these were, even though there were different shareholders in DECA 2, the purchase was for the entirety, and it was subject to the entirety. And so that was used. And again, I reiterate that that criticism was never one that was raised in the original arbitration. So it was something that was newly raised by Dr. Abdallah in the resubmission. And with respect to the costs, there, as I explained, Mr. Kaczmarek had forecasted the costs in the but-for scenario, looking at X's actual costs, what it would have incurred in costs absent the measures, and going back to the pre-measure date, whereas Dr. Abdallah wanted to use the costs of a hypothetical company, which then was discussed as well. That would not make sense, because while you set the VAD based on a model efficient company, if what we're trying to establish is what would EXA really have earned absent the breach, you should look at what its revenues would have been, but what its costs would have been, and you look at actual costs. And that was, debated as well. And in our view, understood that it would make no sense to use hypothetical costs in that instance.
One thing is what
Yes.
you think more appropriate. Did Dr. Abdallah concede that point?
I would have to see if it was an express concession. I understood from the tenor of the hearing that that is how I would have perceived it. But we would have to, I will not say that he conceded it per se.
And when you say that Dr. Abdallah suggested using a hypothetical company's OPEX, was that equal to using what was forecasted in the Bates and White study, or was it he referring to another hypothetical company?
Don't believe that he picked, I would have, let me double check. I don't know that he picked it up from that study in particular. Yeah, let me double check though.
Okay,
So
and a follow-up question. What costs did the original tribunal use to calculate the hysterical? We're all becoming hysterical. The historical damages in the but-for, not the actual.
Right, in the but-for. And again, I will triple check, but given that we maintained the same methodology throughout, I am nearly certain that they would have used EGS's actual costs in order to move forward, just like Mr. Kaczmarek did to forecast, right? That they were not using the hypothetical company's costs in the but-for scenario. They were using the actual costs, and that because our methodology didn't change. And like I said, this was a new objection raised by Guatemala in the resubmission proceeding that they had not raised in the original arbitration. But I can also confirm that at our next break.
They could have used the Bates and White's cost, for example, in the but-for. I mean,
I don't believe so.
That they could, or that they did?
I'm sorry.
That they could have used it, or that they did use it?
Did not use it.
They did not use it. If you can just confirm what they used, what approach they used to calculating the costs in the but-for scenario of the historical loss.
Right.
Do you understand the question? You look at me kind of, let's go through this together. So the historical loss that was decided by the original tribunal, they also had to do a but-for and an actual value. And the difference for the period 2008-2010, that was the damages awarded, and those were the 21 million. And I'd like to know how they construed the but-for scenario and what approach they used to determining the cost. Is that clearer now?
It is clear. I don't know that we will have a definitive answer by 2 p.m.
Okay.
But we have some thoughts on this point that I think address the concerns by the chair. They do not speak specifically to this form of the question, but to a different angle that shows the same consequences. Whenever the committee considers it's our time to address this.
And I just know we will confirm, but I do think that they did use the actual costs in the but-for scenario to calculate historical losses in the original arbitration, because again, Mr. Kaczmarek's methodology did not change throughout. So I think that assumption was the same, but I will confirm that.
But the actual costs, Ms. Menake just told me, those actual costs were brought down because of the measures introduced. So it wouldn't have made sense also for the historical part to have used the actual cost in the but-for, because then the gap would have been bigger.
But they may have projected it again as of an earlier date, because it's the same date, we used the end of the year 2007, which is prior to the VAD being adopted in August 1st, 2008. So for historical costs from 2008 to 2010, you could still do that same forecast, right? Bringing the 2007 actual costs up to 2010, which is what he would have done in the original arbitration. And then he just brought it forward from 2010 to 2013, still forecasting off that same date, the 2007 actual costs.
Well, if those were, but those wouldn't be it would be the actual costs before the measures were implemented.
It is before the measures.
Okay,
because
yes, I get it now.
1st, 2008.
Good. So it would still be a but-for. Because it was a reality 2007,
correct.
Not a reality 2008.
Correct. And as I'm speaking through it, I think that has to have been the case, because the model was the same, right? So in the original tribunal, you have the cash flows, they just cut it off at 2010, and then it continues through. And it's not like the methodologies for doing those, but for cash flows, those for costs changed. He didn't change that in his model.
Okay. Thank you.
And then the only other thing that I would note in response to your question is that the tribunal, as Mr. Plachik showed yesterday, was alert to these 4 issues that were out there. And you saw that they looked, when you set them off all against one another, as you noted, the impact was, I believe, 18.2 million. And there's a footnote to that effect in the resubmission award, noting that is the difference.
The 8 million.
So
this is on slide 99 of TECO's opening presentation, which shows the paragraph where the tribunal made its ruling. This is paragraph 1 38, and let's see if we can maybe put that on the screen. We will go to slide 99. Okay, so on the right-hand side, resubmission award paragraph 138. This is just an excerpt of that long paragraph. That's the reasoning, or part of the tribunal's reasoning. There is a footnote to day one. It's highlighted. It's page 91 in the transcript, pages 4 and 7. And that is a reference to Dr. Abdallah's four criticisms and the cumulative impact of those criticisms as he presented them was that the damages would be reduced from 26 million to 18.2 million, not zero, 18.2. That's all the impacts taken together according to him. And so what this tells you is that the tribunal was aware of these criticisms and considered them because it included a footnote to that portion of the transcript where those were discussed. So we know that this is not something that the tribunal omitted, did not consider, forgot, as Guatemala puts it. We have a footnote right there which cites those criticisms and the amount.
Thank you. I think Guatemala wants to add something.
Sure, I just will
Yes.
ask if they want to add, or did you want us to comment on their statements about the alleged contradictions in the award? Mr. Polachek had something to say about that. Would you like to hear that now or after?
1 second. Let me
Sure.
just see what Guatemala.
No,
You-
it's just, we understood the committee had asked a question of both of the parties. You heard TECOs on this point, you heard us on the contradiction. We're on the hands of the committee, whether you would prefer that they respond to the contradictions and then us on this issue, or us on this issue and then on the contradictions.
Is it your understanding? Is it Guatemala's understanding that the first criticisms regarding whether the cash flow to the equity or to the enterprise, and thus whether the return on the equity, or rather the WACC, should be used as a discounting factor, did Mr. Abdallah somehow waive that criticism?
Not at all. There was
Not at all.
absolutely not.
Good.
In short, and the very short discussion on this, we could perhaps summarize as follows. One of the parties was making a case for 26.8 million, and
Yes.
the other was saying, no, it should be 18.6.
That was the starting point.
It's
Yes.
still the final point.
Okay, but in between
Nothing
there was
changed.
some discussion. And remember that was a part of an examination carried out by Mr. Alexandrov, so questions from the tribunal saying, but how would a third party reasonably establish the value? Would it value each shareholder's share in the company, or would it do it as a whole? That's what I think I understood from the transcript.
And so we have it. It's I think slide 100 of TECO's. I think is it the opening and closing presentation? On TECO's opening presentation, where this citation appears. It's right here. So these are two completely different things. It's one thing to say whether the transaction would be with the individual shareholders, which may or may not reach the 100% of the equity in the entity. And a very different thing to establish how the price to each of those shareholders is established. There's no admission by Dr. Abdallah, no, there's any reason to make any addition that the fact that the purchaser was different and that each transaction was calculated different would have any impact on whether you would make the calculation based on free cash flows to the shareholder or the entity. There's nothing in this transcript or anywhere else we've heard with an admission that these criticisms should be reduced. That's the thrust of
Regarding
what we want to say.
OPEX, was that dealt with at all, or was there anything resembling possible admission, concession, or nothing
There
of
was
the kind?
there were no post-hearing briefs. There were no further reports by the experts. There's no reduction from the petitum in the last submission by each of the parties, and with the
That was OPEX dealt with during the hearing. The OPEX in the but for scenario.
yes, because the discussion and the examination we saw a snippet of some of the questions. Those were the 4 questions that Dr. Alexandro and then Arbitrator Lowe said, these are the things we need to delve into. And so they addressed, we didn't read through the entirety of the discussion in each of the 4,
Okay.
but there was a
But they
reference
were
that the
all
4 would be
addressed.
discussed.
And do you agree that the elasticity and inflation criticisms, that these two wash somehow out and they cancel each other out? And that Mr. Abdallah said, yeah, that the only difference is a 0.1 million and that's negligible.
Yes, and we showed yesterday a portion, I think it was paragraph 251 and 252 of Dr. Abdallah's last report. That was always netted out. If you see, I have a reference version they want to take.
Because I know there was a discussion with Kaczmarek, but then Abdallah was giving the opportunity to comment and on that.
If we can go to
Yes.
REA 25, that's the third compass report page. I think it's going to be 80. There's a chart there. Yes. So this is from I think it's the last report by Dr. Abdallah, correct? And so there's 4 criticisms, but there's 3 lines because everything's netted out, and that explains the difference between 26.8 and 18.2. And what Dr. Abdallah was opining in the last report is that when you take the aggregation of all of these 4 criticisms, that justifies the difference between 26.8 and 18.2. And it's always, 3.7 one way, 3.8 on the other. That difference is already accounted for in the difference. Thank you, Madam President.
Thank you. Thank you. That was very helpful from both sides. Would you like to add anything, Mr. Polashek?
Just maybe one point, and that is what we just saw on the slide, the bars.
Could you please just share that again?
Yeah, and maybe we can look into it and address it in writing. But what Dr. Abdallah did is he had his 4 adjustments, and those cumulatively resulted in the 8.2 million number in interaction with one another. So the fact that we are seeing the other on the right-hand side as in this chart, that's the last gray bar on the right, negative 1.5. So those would be the elasticity of demand and inflation. And each of those individually, one was 3.7 million up, the other was 3.8 million down, or vice versa. One was 3.7 one way, the other was 3.8 the other way. And that's what was discussed at the hearing. That's the discussion where Dr. Abdallah agreed, and you would see it in the transcript, he agreed that these wash out. That's the term that was used by the experts. The reason why they wash out is that individually they are the same number except in opposite directions. On this slide, the number you're seeing might be different because we might be looking at the cumulative impact, or it's broken out in a maybe slightly different way. But at the hearing, it was made clear that those criticisms wash out.
So sorry, I do not have any further questions on damages or interest. I thought Mr. Polacek had said he had something prepared regarding the inconsistencies that suggested the alleged inconsistencies and contradictions of the award. Is it very long?
No, it is very short. In fact, I would just, by way of summary,
it's fine if you address it.
since time was devoted to it this morning. So it goes to the but-for value as it was presented by Guatemala, nothing else, the but-for value. They identified two alleged premises. Both of those.
Okay, they is Guatemala, not the
they Guatemala, not TECO. Guatemala identifies two alleged premises. Both of those, all of those paragraphs are contained exclusively in the part of the award that deals with res judicata, nowhere else. And the question that was before the tribunal there is whether the original tribunal's decisions on the historical damages are res judicata with respect to the loss of value damages. That was the question. And as part of that question, what the tribunal was doing there is it was looking at whether, in light of the original tribunal's rulings, there might be other factors that if the original tribunal had had those, it might have ruled differently. And so that's why you see this language in there, whether it is possible, whether it might be possible, whether that it cannot be assumed, and so forth. So basically, the tribunal concluded that, yes, there might have been other things that the original tribunal could have considered, and it set forth what those other things could have been. And then it proceeded from that to conclude that there was no res judicata. That's what the original tribunal was doing in that section. The original tribunal was not setting forth any premises or anything on which its own analysis of quantum would be based. That analysis is provided in an entirely different section of the award. That section does not cite back to the res judicata or does not espouse these alleged premises. And that's because it was open to the resubmission tribunal to make its own conclusion. And that conclusion could have been that whereas the original tribunal considered the evidence that was before the original tribunal insufficient for awarding loss of value damages, this tribunal, the resubmission tribunal, reaches a different conclusion and considers that that evidence is sufficient. It was open to the resubmission tribunal to make that decision in theory. And in fact, we know that the resubmission tribunal did not only consider the evidence before the original tribunal. And we know that because in the reasoning that's set forth in the other section of the award, where the reasoning on loss of value damages actually is stated, there are references to Kaczmarek's fourth report, which was presented in the resubmission arbitration, to Abdallah's testimony at the hearing. There are references to the record before the resubmission tribunal. And so this notion that there are these two premises that somehow are contradicted by the tribunal, by the resubmission tribunal's conclusion on damages is just not. It's not supported. It's not in the award. That's all I had to say on this.
Thank you. Thank you. Is there anything else you'd like to add? Good. So, and with this, we move on to the questions. And yeah, but there were like a couple of them that they wanted to address, so I'm going to hear them. Yeah, we've got 2 hours, and I'd like to hear the parties' position of what they suggest, how we could make best use of these 2 hours. that are left? In view of the fact that we've got 24 questions.
Well, I give you just kind of a thought from the top of my head. I think that there are a couple of things that it can be taken advantage of the fact that we have, for example, the state representatives here. For example, how Guatemala, I think is question 13 or something, got to know about the Mr. Alexandrov situation. Let me see if I can find the question. And also, I mean, I have some. I mean, we are prepared to respond to the 24th question. We prepared to go through each of them one by one. But otherwise, I mean, I think that we can express, convey to the Annulment Committee some general thoughts about the different topics and kind of the first thoughts, and we can complement things separately in writing. But that's an idea.
So would you agree? Or you expect me to understand your handwriting? All right. Okay. Well, would you then suggest, for example, that we allot 30 minutes to each party and they give us an overall answer to some of the questions and the rest would be submitted in writing? Is that
maybe what I was suggesting is 5-10 minutes for different topics. I mean, we have kind of chunk of different topics that can be discussed, I think.
we've already
And provide an opportunity for the other side. Yes, exactly. Following
so would you say like 5 minutes for each of the sections that are
for
included?
example, and to provide the other party
Because
the opportunity
so
to
that
comment
there's a
on
level playing ground here. So
Exactly.
playing field. Ms. Menaka. What would be your suggestion?
I think in smaller doses might be more efficient. I'm in the committee's hands, of course. If you want to give the parties 30 minutes each, that's fine, but there runs the risk it'll be maybe perhaps less responsive because it'll be more general and a reiteration of some things you've heard over the last couple of days. So it might be more helpful if there are specific, I mean, at this point, I think it's a foregone conclusion we'll have to answer in writing. So if there are specific things that you think that you might have a follow-up question to, or that it would really help to hear the parties' views on now, maybe if you would identify them and then we would each take, a few minutes to answer that. That would be one suggestion. And then the only other reaction that I had is just a little bit of concern that I had expressed earlier in the hearing that, of course, Guatemala may choose whomever it wants to address the tribunal. That's not the issue, but we're not here to hear witness testimony.
No
so if
witness
it's legal
testimony.
argument,
Yes.
fine, but not witness testimony. When he was talking about what they knew, that's factual.
I understand anyway. Ustedes, ¿desde cuándo funge usted como procurador?
How long have you been the Attorney General? Thank you, Madam President. I have been in this position for 2.5 months. So a person in our team was going to refer to the facts. It's not that we were going to have a witness. But at any rate, whoever is going to address this does not have firsthand knowledge as a witness, as a potential direct witness. Mr. Smith, myself, and Ms. Carla Liquez, the members of the Office of the Attorney General, all of them were direct witnesses of the facts.
We need to have a chat. Yes. Let's break for 5 minutes.